Good morning, everyone. During the first day of her historic Senate confirmation hearings, U.S. Supreme Court Justice Ketanji Brown Jackson reminded us all of a judge's duty to rule without fear or favor, and to decide cases from a neutral posture. Today's decision is a result of the execution of my judicial duties and careful analysis of the facts of this case and the evidence presented at the three-day evidentiary hearing last summer. I took my time evaluating the case because I will never allow my significant caseload or any time pressures to transcend justice. I recognize that while I adhered to the rule of law by interpreting and applying the law, including the U.S. Constitution, case law and precedent, and rules of court to the evidence presented, there will be some who will not agree with the decision I render today. But my job is to not take into account any of that. My job requires that I have the courage to do what is right, regardless of the pressures of public opinion, political considerations, or anything else. I acknowledge that it is incumbent upon me and all judges to have the courage to stand between abuse of governmental power and the individual standing before the court. Because I am entrusted to protect the liberty of the people and to be a guardian of a system of justice that protects our democracy. On September 3rd, 1994, Rhoda Nathan was attacked in room 237 of the Embassy Suites Hotel in Blue Ash, Ohio. She was there with friends, and when her friends went to breakfast, she stayed in the room to shower and get dressed. Her friends returned to room 237 approximately 30 to 40 minutes later. When they opened the door, they discovered Ms. Nathan unresponsive, laying naked and face up on the floor. Initially, Ms. Nathan was thought to have suffered a heart attack and injured herself in a fall. However, after determining that she had suffered multiple traumatic injuries and blunt force impact to her head and torso, the Hamilton County Coroner's Office classified the death as a homicide. An investigation ensued by the Blue Ash Police Department. A detective testified that he found a pendant resembling the victim's in a search of a toolbox in the trunk of Elwood Jones's car on September 14, 1994. On September 27, 1995, more than 1 year later, police arrested Elwood Jones for Rhoda Nathan's murder. Jones was subsequently tried, convicted, and sentenced to death in 1997 based on the investigation of the Blue Ash Police Department and the evidence presented at trial by the state of Ohio. For approximately 27 years, Elwood Jones has consistently maintained his innocence and claimed that his November 1996 trial was fundamentally flawed. Now, at the trial, the identity of the perpetrator of Rhoda Nathan's murder was the central issue. The state's theory of the case was that Elwood Jones murdered Ms. Nathan and gashed his hand during the bloody beating of her in room 237 of the Embassy Suites Hotel. That the bacterial infection that Jones had in his hand in September 1994 could only have been caused by a clenched fist injury. That Elwood Jones, who was an employee at the time, of the hotel had to have a master key to the Embassy Suites Hotel to access Miss Nathan's room, and that Miss Nathan's pendant, which was unique and made from a family heirloom, was found in Jones's car. Now, Elwood Jones has unsuccessfully challenged his conviction on direct appeal in a timely petition for post-conviction relief and other post-conviction filings. His claim for a new trial and the merits of that claim are now before this court. Elwood Jones has moved for a new trial based on newly discovered evidence and prosecutorial misconduct pursuant to Criminal Rule 33 and the principles of Brady v. Maryland. Relevant here, Criminal Rule 33 permits a trial court to grant a new trial when new evidence material to the defense is discovered, which the defendant could not, with reasonable diligence, have discovered and produced at trial. However, where the newly discovered evidence was suppressed by the state, such evidence is properly analyzed under Brady v. Maryland. Otherwise, it's governed solely by Rule 33. But whereas here, the motion for new trial raises both of these grounds, the Brady analysis is controlling. Thus, the court's analysis begins with Brady. Now, the Brady principle is a rule of fairness. The motivating force behind the Supreme Court's decision in Brady was the belief that society wins not only when the guilty are convicted, but when criminal trials are fair. Our system of the administration of justice suffers when any accused is treated unfairly. Brady's progeny has broadened the duty of the prosecutor by establishing that a prosecutor has a duty to learn of any favorable evidence known to the others acting on the government's behalf in the case, including the police. The Brady rule applies equally to impeachment evidence, which, if disclosed by the state and used properly by the defense, may make the difference between a conviction and an acquittal. In order to prevail here, Mr. Jones was required to show three elements of his Brady claim. One, that the prosecution withheld evidence. Two, that the defense was not aware of the evidence. And three, that the evidence withheld was material. Now, the final element of materiality does not require that the suppressed evidence would have resulted in acquittal. Rather, the touchstone of materiality is a reasonable probability of a different result. A reasonable probability of a different result is shown when the government's evidentiary suppression undermines the confidence in the outcome of the trial. During the evidentiary hearing here, it was established that nearly 4,000 pages of evidence, including police investigative notes, witness statements, and 400 pages of hotel guest questionnaire responses, was withheld from Jones's defense team prior to trial. While the state did produce some discovery, over 260 pages, and access to physical items, the undisclosed documents were replete with impeaching and exculpatory evidence. Based on Jones's post-conviction efforts, the defense now has, from the investigative files of the Blue Ash Police Department, evidence the defendant was not aware of before trial, including statements from several hotel guests who witnessed several security breaches at the hotel on the day of or near the time of the murder, one including Rhoda Nathan. They now have a statement from Robin Williams Budd, a hotel guest who witnessed on the morning of the murder a white male, late 20s, thin build, medium length brown hair, 6 feet tall, wearing dark clothing, walking rapidly out a hotel door, propped open by a yellow cup, and running through the parking lot and sprinting into the woods. The defense now has a number of documents pertaining to another potential suspect who worked at the Blue Ash Embassy Suites Hotel and was present on the morning of the murder. The defense now has investigative statements from 2 hotel employees, Demetrius Williams and Ryan Norman, who separately informed the Blue Ash Police Department that they saw a white and black man leaving Ms. Nathan's room on the morning of the murder, with the white guy running out of the room and the 2 men separating in different directions when they came out. The defense now has witness statements by several hotel employees concerning a number of master keys to the hotel that were in circulation and unaccounted for, that the Blue Ash Police Department did not investigate. The defense now has inconsistent information by the Blue Ash Police Department regarding which specific officer recovered the pendant, which was a crucial piece of evidence in the state's case found in Mr. Jones's car. And the defense now has evidence that the Blue Ash Police Department traveled to New York City to meet with Ms. Nathan's family about Ms. Nathan's pendant and learned that it was not unique or made from a family heirloom. Additionally, evidence at the hearing established that there were several documents pertaining to hepatitis B tests that the state conducted, which revealed that Ms. Nathan tested positive for hepatitis B, but Elwood Jones, his blood did not and never has. In fact, evidence of Ms. Nathan's hepatitis B status was known to the state, but not disclosed to Jones or his defense team prior to trial. Even more significant was the fact that the state tested Jones's blood for hepatitis B on September 15, 1994, and the results were negative. The state's decision to test Mr. Jones's blood and the results were also not disclosed to the defense prior to trial. Accordingly, the court finds that there was evidence withheld by the state. The court's next analysis has to be whether or not the evidence that was withheld was also material. The hepatitis B evidence. The full import of the undisclosed evidence of the state's decision to test Jones's blood for hepatitis B and the negative results that followed was fully explained by the testimony of Dr. Stephen Burdett. Dr. Burdett, a professor of medicine and chief of infectious diseases at the Wright State University Boonshaft School of Medicine, testified as the defense expert in infectious diseases. Dr. Burdett testified that hepatitis B is a highly contagious virus. In fact, he explained that hepatitis B is more contagious than hepatitis C and significantly more contagious than HIV. And even though when it comes to bloodborne pathogens, people worry about HIV because of the stigma that comes along with it, hepatitis B is dramatically more contagious if somebody gets exposed to the blood. Dr. Burdett noted that studies done on a needle stick blood exposure, that is, exposures based on tiny pricks with needles that have only microscopic traces amounts of blood, established that there is a 33% chance of infection of hepatitis B in those instances. He went on to explain, though, that the more blood that you're exposed to, the more virus your body can be exposed to. Therefore, the more likely your risk for infection would increase. Dr. Burdett further explained that he had reviewed the records about the crime scene, about Elwood Jones's hand injury, and testified that it was a bloody scene with a laceration on Mr. Jones's hand. Based on that, Dr. Burdett testified that it was his expert opinion that Jones would have hepatitis B if what the state says took place had in fact occurred. Of course, as Dr. Burdett went on to explain, Elwood Jones does not have hepatitis B. In addition to the September 15, 1994 negative hepatitis B test that the state conducted and withheld from Jones, Dr. Burdett reviewed a more comprehensive May 26, 2022 test confirming that Mr. Jones does not have active hepatitis B, was never immunized for hepatitis B, and never had a prior hepatitis B infection. In other words, the hepatitis B tests that the state withheld were important medical information that directly undermined the state's theory. Moreover, Dr. Burdett testified that the disparity in Ms. Nathan's blood test results and Jones's blood test results is so significant that the state's theory is scientifically implausible. Accordingly, the court finds that the hepatitis B evidence was material and withheld. The alternate suspect evidence. Throughout Jones's trial, the state argued that Jones was the only person with a motive and an opportunity to kill Rhoda Nathan. But neither the jury nor Jones's defense team knew at the time about another man's possible involvement in the murder. At the hearing on the instant motion, the defense persuasively argued that it was unaware of and the state failed to disclose evidence pertaining to a witness's communication with the Blue Ash Police Department before trial regarding a reported confession to the commission of the murder by someone other than Elwood Jones. Now, the state also argued that it was also unaware of this evidence prior to trial because there is no record of this communication in the Blue Ash Police Department's files. Ms. Dolores Suggs testified that she was released from the Hamilton County Justice Center on November 17, 1995. She testified that around 2 weeks after she was released, she called 911 and was directed to the Blue Ash Police Department. This is significant because Ms. Suggs testified that she was in the Hamilton County Justice Center with an inmate named Linda Reed, who told her that it was her husband, Ms. Reed's husband, Earl Reed, who had confessed to committing the murder at the Embassy Suites Hotel and framing a Black man for his crime. Ms. Suggs testified that she communicated this information to the Blue Ash Police Department. However, she testified that the Blue Ash Police Department was not interested in what she had to say. The person Ms. Suggs spoke with at the Blue Ash Police Department, she testified, told her that it was a closed case because they had found something in a man's possession. Although the state contends that it has no record of Ms. Suggs' 1995 call to the Blue Ash Police Department, Ms. Beth Ann Moyer, who was a defense expert in police investigations, testified that in light of the Blue Ash Police Department's failure to generate a call log for this case, the lack of a report memorializing the call is in no way indicative of the call not being made. Ms. Moyer noted references in the Blue Ash Police Department files to a radio broadcast and a press release offering a $10,000 reward for helpful information in the case. Based on Ms. Moyer's years of experience, she testified that a reward of that size made known to the public would have garnered a lot of attention and a lot of calls. The Blue Ash Police Department should have had a log where each call was documented, the date and time it came in, who took the call, and who spoke with the person and what they said generally. Yet Ms. Moyer testified she did not find any evidence of any such call log. Likewise, the lack of documentation regarding a call about Earl Reed does not mean a call was not placed. After all, the evidence established there was a myriad of leads and suspects that the Blue Ash Police Department failed to document or follow up on. Accordingly, the court finds that the alternate suspect evidence was material and withheld. The evidence of the pendant. A crucial piece of the evidence to the state's case at trial was a pendant allegedly belonging to Ms. Nathan that the Blue Ash Police Department found in Jones's car. At trial, the state represented to the jury that the pendant was unique and that her husband had it custom made for her. In fact, the state told the jury it was as if Rhoda Nathan left her print with the defendant. However, the evidence established that the state failed to disclose that prior to trial, members of the Blue Ash Police Department flew to New York to meet with Ms. Nathan's family about the pendant. Notes in the investigative file of the Blue Ash Police Department that was not disclosed to the defense established that officers spoke with Ms. Nathan's family members who informed the police that the pendant was not a custom-made piece and that the engagement ring that the family originally thought the pendant was made from was in the possession of one of the family members, Ira Nathan. Ira Nathan told police that he thought the pendant had simply been brought from a jewelry store in the Bronx. Ms. Beth Moyer did not see any evidence in the investigative file that the Blue Ash Police Department gave any credence to the family's claim that the pendant was not custom made. Nevertheless, this court finds that this evidence is material, and suppression of it undermines the confidence in the outcome of Jones's trial. I am not going to read the entire decision because I have it prepared for the parties to see, and it will be filed of record in just a few minutes. But let me say in conclusion, the police investigation of the murder of Ms. Rhoda Nathan was mishandled by the Blue Ash Police Department in 1994. By the evidence, there are many unanswered questions about the events that occurred at the Embassy Suites Hotel in Blue Ash during the weekend that Ms. Nathan was killed. Unfortunately, this mishandling resulted in the jury considering evidence based on an incomplete police investigation and flawed circumstantial evidence. Additionally, the jury did not have the benefit of considering material evidence which was known to the Blue Ash Police Department and the state prior to trial, but not disclosed to the defense. When prosecutors withhold evidence that they are duty-bound to turn over, they undermine the Constitution, the Supreme Court's case law, and the premise of justice. Brady violations not only send potentially innocent people to prison, but they reinforce a win-at-all-cost mentality that undermines the pursuit of justice. As noted by the U.S. Supreme Court, a prosecutor should not be the architect of a proceeding that does not comport with the standards of justice. Such failures violate a defendant's right to due process of law under the 5th and 14th Amendments and thwart the various protections that together constitute the fundamental right to a fair trial under the 6th Amendment. For reasons stated herein, the court finds that the state failed to disclose prior to trial information received about Earl Reed's reported confession to the murder of Rhoda Nathan, the hepatitis B test results, and almost 4,000 pages of investigative notes, witness statements, and questionnaire responses. The undisclosed evidence contained in those investigative materials, along with other newly discovered evidence, serve to undermine the credibility of the state's key witnesses and provide the fundament for the medical expert's opinion that Jones's hand infection was caused by a clenched fist injury because of the presence of Eikenella corrodens. Therefore, the evidence presented at the hearing on defendant's motion for a new trial demonstrated that the undisclosed evidence was material in the sense that it undermines the confidence in the jury's 1996 verdict that Elwood Jones caused the death of Rhoda Nathan as charged. Additionally, the undisclosed evidence demonstrated that the state's violation of its duty to disclose material evidence had effectively precluded Jones from learning of the existence of that evidence and of the proposed grounds for a new trial until his defense team's post-conviction diligence and the communication from Tierra Suggs uncovered the evidence. Whether the state acted in bad faith or out of negligence when failing to disclose material evidence to the defense, which could have arguably changed the outcome of the trial, it is clear that the failure to disclose the existence of relevant, exculpatory, and impeaching evidence prior to trial deprived Elwood Jones of a fair trial. The Sixth Amendment requires a new trial as the only appropriate remedy. Accordingly, Elwood Jones's motion for a new trial is hereby granted. In light of the foregoing, it is further ordered that this matter shall come before the court for hearing in this room on January 12th, 2023 at 10:30 a.m. Court has concluded.
Thank you, Mom. Thank you, man.